7. My name is Kenneth Lukwago Anderson, your host, and today we'll be looking at the unending debate about the trial of civilians before military courts. Now, we know the recent arrest and trial of Dr. Kizza Besigye and his colleague, Lutale, has yet again rejuvenated the discussion about the relevance and legality of trying civilians before military courts. Now, while lawyers, including those representing the two, insist that it's wrong for the military to be trying civilians, the military has insisted that they are empowered by the law and several rulings delivered by the courts in Uganda to actually carry out such trials. There's a document which was issued today by the Office of the UPDF and Ministry of Defense spokesperson titled Systematic Attacks Against the Military Courts, specifically the General Courts, Marshal, and its members, a work of ill motives. So they are saying that all those who are opposed, who are speaking about this particular matter, have ill motives. So with that said, why don't we bring both parties on the table to try and understand what exactly is going on and how we can arrive to, an amicable situation. After all, what matters most is justice for those who are being tried. I have two guests in studio, but there are three now. Originally, we invited two people. I'll introduce them, and then the third person will be introduced by the person who has actually asked them to accompany them. Let me introduce Mr. Aaron Kizza, advocate and pundit on governance and human rights issues. Good evening, Councillor Aaron Kizza, and thank you very much for joining us this evening.
Good evening. Thank you for decorating me with a pandit. I didn't know that I'm now also a pandit on governance, but it is okay. I happily wear that robe. Should I also call someone? Because since we have guests have started calling people back up, do I need also to ring?
No, you don't have
okay,
to.
Thank you.
Is it getting colder in the studio?
I'm related. When the military is in an area, the temperature rises, so I have to put on this jacket. Thank you.
All right. Our second guest, Colonel Deo Akiki, Deputy UPDF and Minister of Defense and Veteran Affairs spokesperson. Good evening, sir. Thank you very much for joining us.
Thank you, Kenneth. Thank you, listeners, and I'm happy that in the military we have what they call reinforcement. So we move with all our credentials, and reinforcement is acceptable.
And I can see the medals also.
By God's grace, there is some recognition.
So you came with a colleague. If you can kindly introduce to us, or if we can allow him to introduce himself.
Yes. Mr. Aaron, Council Aaron should not get worried.
Aaron
Kizza,
yes,
Council Aaron Kizza, that the reinforcement could be for security purposes. No. It's because I don't want him to box me into a ring. Whenever I put him somewhere, he wants to put me where I'm not conversant. So today I have moved with Council Achilles, an accomplished lawyer of the Uganda People's Defense Forces, a lieutenant by rank, and also as one of the testimonies that actually UPDF has lawyers, but he can introduce himself better.
Thank you very much, Afande. I'm Achilles Bweche. I'm an advocate of the High Court, and I serve in the Uganda People's Defense Forces.
All right. You're welcome. Thank you very much for joining us. Now, I'll begin with you, Afande Deo Akiki, because this issue of human rights lawyers and other members of the bar insisting that civilians should not be tried before the court martial has been in the public domain. But you decided today to come out with a response. What is entailed in this response? Why do you insist that civilians should actually be tried in military courts?
Well, we have been explaining this for quite some time, and some people, including my land friends, Council Kizza, decided to continue insisting on this and giving some information we think is not correct. And it was incumbent upon us to explain to the public both in print and electronic media, and we thank you for giving us the space so that we explain to the public what exactly the court-martial is, why it tries people who subject themselves to military law, although they would have otherwise not been so, so that we put the record clear. That was number one. Number two is also to address ourselves to the fact that these attacks and utterances have been so common or have come up so prominently since the arrest of Colonel Dr. Kizza Besigye. And that's why today we came in to clarify more some of the issues and some of the legal matters that are involved. That's why I carried with me a lawyer, an advocate of the High Court, so that we are at the same pace. Both the other side, where my colleague, my friend Aaron Kizza belongs, and this side of the military, when we have those who are experts on legal matters to explain.
All right, very quickly, if you can run us through your arguments, what exactly is your response to these calls that the trial of civilians before court-martials should not be going on?
There are quite a lot of justifications, and most of these are illegal. And I wouldn't want, since today I'm well protected in that legal side, I wouldn't want to delve into them very much. I would right away pass them to Counsel Achilles to explain to the public what this means.
All right. Let's hear from Lieutenant Achilles Bwete, who works with the UPDF. Counsel Achilles...
Advocate of the High Court.
Counsel Lieutenant Achilles Bwete. What exactly is the argument of the UPDF when it comes to this issue of trial of civilians before its courts? Because from the time this issue came up, it's not the first time even with the arrest of Dr. Kizza Besigye. Even in the past, we have also seen there a number of rulings from the courts suggesting that what is going on is actually wrong.
Thank you very much.
If you can come closer to the microphone.
Thank you very much. The issue of trial of civilians, it's not, it's a bit historical. It stems from our constitution, that is a preamble, which recognizes political instabilities that have been in the country, and then it comes to the laws that were made by Parliament. That is the UPDF Act. It was made by the People's Representatives, and the genesis of our constitution that we had a lot of people held guns and topple governments and cause political instabilities in the country. So the military court has done a very good part in, for instance, pacifying Karamoja and ensuring that we have peace in this country. So the trial of civilians is it's constitutional. It's constitutional, and there have been decisions of the Supreme Court, quite a number. Specifically, Hadija Namugera. In the Supreme Court case of Hadija Namugera, the Supreme Court, in a unanimous decision, said that the trial of civilians is what is constitutional and it's legal, as long as you bring yourself into the confines of military law. Namugera deliberately elaborates on this issue, because that's the issue of controversy in Namugera, Hadija Namugera versus Attorney General. It was a Supreme Court decision. It came from the Constitutional Court, and then it went to the Supreme Court, and the Supreme Court pronounced itself on that matter. We don't have any other decision from the Supreme Court that addresses that matter, so we are waiting for the decision of Kabaziguruka if the Constitution is to, if the Supreme Court is to overturn its decision in Hadija Namugera. Remember, the decision of the Supreme Court is binding on all courts as far as trial of civilian is are concerned, but the Supreme Court that is under the Constitution, the Supreme Court can overturn its decision. But as of now, that Hadija Namugera is still good law in our jurisdiction. Yeah, so that's why the trial of civilians is legal and constitutional until the Supreme Court pronounces itself. There are decisions. There is Tumushabe, and they're all discussing this issue, and the Supreme Court is very elaborate about the trial of civilians.
So you insist that you are working within the law as the military to try civilians before your courts. That's what you're saying.
Yes, it's within it's in our jurisdiction. It's within the law,
Mm.
and until maybe Parliament changes the law, that is the law, or until the Supreme Court pronounces itself, overturning those two decisions.
All right. I want to go back a little bit to Kanode Wakiki. Kanode Wakiki, the explanation being given by Lieutenant Bwete is that once you find yourself within the confines of military law, can you elaborate that a little bit? What does that entail so that people can understand under which circumstances can somebody find themselves before a military court?
There are about 3 circumstances according to our laws.
Mm.
Circumstance number 1 is if you are accompanying the military on any mission. Circumstance number 2 is if you are found with military stores or those stores that are a preserve or are a monopoly of the defense forces.
Mm.
Number 3 is if there is, when you are found with our military stores, if you are accompanying us, or if by any circumstances you engage yourselves in 2 acts that are deemed compromising the security of the defense forces.
Mm.
There could be even another 4th circumstance that is not off-head me here. But those are basically some of the areas that pull somebody to subject himself to military law. And these are very well explained in our laws.
Mm.
Why should a civilian be tried in the court martial or be subjected to the military law?
All right. Now, at this point, I'll bring in Council Aaron Kiza. Council Aaron Kiza, you're one of those people who think that the ongoing trials of civilians before the military court-martial is illegal. We have seen you even banging tables in an attempt to explain that matter. You've heard from the security forces. They said there's a precedent by the Supreme Court, a ruling that actually gives them the authority to go ahead and until the Supreme Court changes its mind and makes another order, they will still proceed with that. What would be your response?
First of all, I must mention that whatever has been said by the military on this show is misleading and stands in utter contradiction of the 1995 Ugandan Constitution. Let's start with the preamble which they alluded to. It reminisces about our turbulent past as a country.
Mm.
That turbulent past was particularly caused by violent people, Ugandans, including NRA, including some members who are now in UPDF. The military has played a domineering role in destabilizing Uganda. It is the reason why we have a chaotic history. And to cure that chaotic history, Ugandans in the 1995 Constitution, which they promulgated in 1995, decided that the military should be kept in the barracks. They understood that the role of the military is to defend society, not to define it. But this current military we have is going ahead to define society, to regulate society, but also to commit crimes, like the General Court Martial is currently committing the crimes of wrongful confinement, the crimes of abduction and abetting of abduction, the crimes of violating non-derogable rights contrary to the Human Rights Enforcement Act, the crimes of torture contrary to the 2012 Prevention and Prohibition of Torture Act, the crimes of contempt of court contrary to Article 28, Clause 12 of the Constitution, undermining rule of law, good governance and transparency as adumbrated in the Treaty for the Establishment of the East African Community, jeopardizing and undermining rights under the African Charter for Human and People's Rights, and also shredding our constitution into tatters. the primary constitutional provisions, and I talk about the constitution because it's the primary law governing this country. Any other decision, speech, custom that tends to threaten or undermine the constitution is null and void to that inconsistency. The UPDF Act, the parliament, even the Parliament of Uganda has no power to grant military tribunals, kangaroo military tribunals like the one in Machinde, calling itself the General Court Martial, power to purport to try civilians. The Article 210 of the Constitution is very clear. The only power that they have been granted is to discipline and remove members of UPDF. There is no power that Parliament has under that act, under that article of the Constitution, to discipline non-soldiers or to even enforce criminal law.
All right.
So talking to the Hadija decision, it is very unfortunate that the lawyer in this court has not read the Kabazuguruka case or the Semuju case, which considered Hadija and clearly said that the Supreme Court in a criminal appeal has no authority to overturn constitutional court decisions.
All right.
The power of constitutional court is by the constitution, which is supreme, and the Supreme Court can only overturn constitutional decision in a constitutional appeal. So the Supreme Court cannot, in a civil appeal or a criminal appeal, purport to vary the decision of the Constitutional Court, and they have not done so. The decisions we are quoting them are two. One of 15th December 2022, the Amon Byarugaba case, and 169 others versus Attorney General, as well as the 3rd February 2023 case of Semuju. None of them were appealed. None of them have been stayed. The duty of each and every police officer, each and every UPDF officer, general, operative rank, warranted SWAT, is to enforce those constitutional court orders. It is not to debate them.
All right.
They know where to go if they want to debate these things.
The argument they are making is that you are relying on a constitutional court ruling when there is a Supreme Court decision.
I have already explained that the Supreme Court, constitutional court decisions can only be varied in a constitutional appeal. The decision they have quoted, not only are they of long ago.
There's a decision by the Supreme Court.
That's what I'm telling you. The decision of the Supreme Court, which is long ago, cannot vary a subsequent decision of the Constitutional Court unless the Supreme Court was handling a constitutional appeal. What you forget is that the thing they are talking about were from criminal appeals, and criminal appeals basically. They were not from constitutional appeals. So a decision of the Constitutional Court can only be varied by the Supreme Court if there is a constitutional appeal. For example, if Kabazuguruka is turned down by the Supreme Court, that is okay. But no other opportunity for the Supreme Court of Uganda has arisen.
All right. Now, we have an issue here where the UPDF also says that once you do things that bring you under the military law, you must face the military courts.
Yeah, because
How
they
can
have
we
not
address that
read,
issue?
because they have not read the Byarugaba decision that tells them that any proceedings entailing civilians before military tribunals are invalid, null, and void from the 15th of December 2022. That's a court order they have a duty to enforce. Anyone from the military purporting to debate against it is committing a crime. The crime is called contempt of order.
So now,
the crime
in your
is
view,
called willful disobedience of
in
lawful
your
orders.
view, when a
So
civilian,
every member of the court martial should be locked up. Police is delaying us. They need to lock up these criminals populating the general court martial and stop wasting our time.
all right, I want to hear from you as a peace-loving Ugandan. In the event that somebody is found to be in possession of firearms,
Let them not
to be
pretend before
causing
you.
insecurity,
Let them not pretend before you.
What advice
Let
would
me
you
tell
give?
you, the advice is that our civilian courts are competent to try civilians and soldiers alike for all crimes, including terrorism, including treason, including, for example, ADF, Allied Democratic Forces, which have declared war on Uganda. Their leader, according to government, their leader was caught. They followed the law. They went for extradition proceedings, and they took the leader, Mukuru, to International Crimes Division. Koyero, same story, is of RIA. What makes you think that the civilian courts which are handling RIA rebels, ADF rebels, cannot handle Ugandans who are found with pistols, on whom they plant capes, on whom they plant uniforms, and so on and so forth. It is pretense. They don't mean these things. You will realize that the people they are trying in the court-martial either belong to National Unity Platform, FDC, People's Front for Freedom, or other government critics whom they want to punish because they know that the military tribunals are instrument for Museveni to silence opposition and his other critics. He weaponizes these tribunals against dissenters and critics. That's the whole purpose. They are serving relative civilians. They are not supposed even to look at a civilian.
All right. Spectrum on Radio 1 FM 90. We need to go for a break now. When we return, we'll ask Afande Deo Kiza to respond to some of the issues that are Deo Akiki to respond to some of the issues that have been made, have been put across by Aaron Kiza, especially on the possibility of actually having civilians tried under the normal Ugandan courts, civilian courts. And his response to the issue of the kangaroo military courts. Now, stay tuned, Radio 1 FM 90. Let's go for a break now. Well, thank you very much for staying with us on Spectrum, live on Radio 1 FM 90. A topic of discussion today, we are looking at the unending debate about the trial of civilians before military court-martials, where we have a group of lawyers and human rights activists who are saying it's wrong, while the UPDF and the government insist that what is going on is actually legal and catered for in the Constitution. I'm speaking to Counsel Deo Kiza, who is one of the lawyers behind the arguments against the trial of civilians, but he's also representing Dr. Kiza Besigye and Haji Lutale in the General Court Martial in Makindye. Also in studio, Colonel Deo Akiki, Deputy Spokesperson of the UPDF and the Minister of Defense and Veteran Affairs, accompanied by Counsel Achilles Bwete, who is a lieutenant in the UPDF. Well, Afande Deo Kiza, we have heard from Aaron Kiza there responding to some of the issues he puts across, and he seems to suggest that it's still possible for you to actually have civilians tried in the normal courts. Maybe you can send your lawyers, like you showed us today that you have lawyers in the UPDF, to go and prosecute these people in the normal courts, so that this hullabaloo of you abusing the rights of people in military courts, like you've had, military courts being used to silence the opposition, those people who are opposed to the commander-in-chief, etc. What would be your response?
Number one, we don't simply wake up one day and stop the law. He's a lawyer, he knows. There is a process of stopping certain provisions that exist in our laws. As far as I'm concerned, and I want to repeat, this time one by one, every person not otherwise subject to military law who voluntarily accompanies any unit or other element of the defense forces which is on service in any place is subject to military law. Number two, every person not otherwise subject to military law while serving with the defense forces under an engagement by which he or she has agreed to be subject to military law is a subject of military law. Number three, every person not otherwise subject to military law who aids or abates a person subject to military law in the commission of a service offense, and every person found in unlawful possession of arms, ammunition, equipment, ordinarily being the monopoly of the defense forces, all of those people are subject to military law. And this law exists. So until it is changed, we can't do otherwise. And there is a process. People have attempted to change this process. They have not been successful. We are not mad to keep trying people without following any law. Then there is, I want to briefly touch my land friend here, Counsel Achilles, will dig into the details of these laws. There is an article, 132, I think, Clause 4, Section 4 of the 1995 Constitution, which provides that the Supreme Court may, while treating its own previous decisions as normally binding, depart from a previous decision when it appears to it right to do so. There are many other details about that. And all other courts shall be bound to follow the decision of the Supreme Court on questions of law. Counsel Achilles will go into details of this. I don't know all of these facts that appear here, why Council Kiza would want to say we should just sit on them and don't consider them, only listen to him. Because I don't think he's maybe the best lawyers we have in town that he can stand on all other lawyers in interpreting the law.
Well, it's not only Aaron Kiza who has been against this issue. We have also heard from other lawyers and even people
We
in
have
civil
heard
society.
from lawyers. Unfortunately, these issues of law, the rate at which the hit they are taking is when there are some issues which are being mixed up. And unfortunately, we are in a very funny period where everybody is trying to pull and push and see who takes the biggest bargain in the political arena. To me, as a lay person, not a lawyer,
But
once
also-
we
but-
mix
but-
up
but
some
also-
of the things
But also
with...
there's some people out there who are actually saying it's you who are probably coming up with these things at the wrong time. You
We
know,
are also
We are
coming-
preparing for the 2026 general elections.
Peoples
and you
are
know
out
Dr.
there.
Kiza Besigye is likely to be a key player. The best way to do it, to slow him down,
Now, let me tell you,
is take him to that court,
let me give you a very lay example.
where it's even hard for him to get bail.
Let me give you a very lay example. From the 12th of this month up to some time, these are festive seasons, no UPDF soldier will be given a leave to go on Christmas, to go and have fun, until a certain time frame we have been given is over, when we are sure the country has gotten out of the celebrations where people relax and so on. Do you know why we do this? It's because our enemies sometimes take advantage when everybody is relaxing.
No, actually,
what I'm trying to tell you,
it's what you signed up for.
Yes, but,
Yeah, that's what you
but
signed up for.
security, the matter we are discussing also involves security. And we have seen situations, not once, not twice, very many examples across the world. When the political moments come, we have people who take advantage. They say, oh, it is a political moment, so I can hide into politics. You are deceiving yourself. We shall continue to manage the security of this country, whether it is political time, whether it is festivities. For us, we shall do our job. Anybody who goes against the laws of this country, anybody who tries to do something that destabilizes this country, we don't care at what time you do it, we shall come in.
All right. You wanted Council Bwete to expound on something. Kindly, if you can do so very quickly, and then we bring in Aaron Kiza. We also have the listeners who are sending in their views. We will also need to hear from them.
So very quickly, I would go to the recent decision that of the Supreme Court that Council Aaron has quoted. When you look at paragraph 10, I want to verbatim to quote what the Supreme Court was saying.
Which one?
That is Ambrose Ogwanga. It was decided on 11th of December.
Just last week.
It says that, in our view, the body of the UPDF Act specifically sets out the army courts as parallel judicial framework, distinct and juxtaposed against the courts of judicature. So it appears to have been contemplated that UPDF Acts were better placed to discipline issues within the rank and file of the UPDF. So you look at they are parallel, they are courts of they are courts, and in Tumushabe they are called subordinate courts that are created under Article 129, 129(1)(d) as subordinate courts. So the Supreme Court has pronounced itself on the legality of these military courts.
And says that military courts should strictly handle issues of discipline within the forces. That's what you've read there.
Yes, but also when you look at Namugerwa, the case of Namugerwa, a decision of the Supreme Court is valid until it's overturned. And we follow the Constitution. When you look at Article 132, jurisdiction of the Supreme Court that Afande Akik has pointed out, it says that the Supreme Court may, while treating its own previous decision normally binding, depart from its previous decision when it appears right to do so. And all other courts shall be bound to follow the decision of the Supreme Court on the question of law. So the Supreme Court decided in Hadija Namugerwa and decided in Tumushabe. So you cannot quote a court of appeal decision when there is a Supreme Court decision. So I would agree with Council Aaron Kiza if the Supreme Court pronounces itself on the issue on the case of Kabaziguruka that is pending before the Supreme Court.
Are you well acquainted with the issue of Namugerwa? What exactly was the issue there? Was it a reference from the courts of appeal, or was it an issue that just found itself there?
Namugerwa came. It was a decision by the Supreme Court, and it came from the. It was.
It's a criminal appeal.
It came challenging the trial. The issue was whether was trial because a civilian was arrested, and then he was charged in the general court martial. So the matter went to the Supreme Court, and where the issue is whether it's whether a military court can try a civilian. So the court. The
Namugerwa case was before the Kabaziguruka one.
It's around 16 years
Much
ago.
later.
16 years
Much
ago.
later.
Kabaziguruka
So-
is
Much earlier, much
So
earlier.
should we say the judiciary in making determinations, including the Constitutional Court, does not refer to what the Supreme Court has decided?
Yes.
Surely they would have used that as a precedent.
The Supreme Court the Supreme Court binds, like the article we've read.
Yes.
The Supreme Court binds all other courts. all the
I
small
understand,
courts.
but then the Constitutional Court did rule in the issue of Kabaziguruka that it is wrong to try civilians
And
in
it
a
has
military
ruled
court.
in Amon Byarugaba, but we are waiting for the decision.
There are no ifs and buts
All right.
with court
Aaron,
orders. There are no
Aaron.
ifs and buts.
Can we understand that situation? The Namugerwa case is as old as 16
Not
years
only,
before the Kabaziguruka one.
not only is it an old case, it was not a constitutional
But
matter.
it remains on record as a
Yes.
Supreme Court decision,
Yes.
which is
in a
binding.
criminal appeal, no, it's not binding on the constitutional court
Why?
because it's not a constitutional appeal. It's not a constitutional matter. I have been very clear. The Namugerwa decision was a mere criminal appeal. It was an ordinary court process. It was not a constitutional appeal from a constitutional petition.
So you're saying in making its decision, its determination, the Constitutional Court cannot refer to that ruling
It can refer
because
it,
it's from a superior court.
hold on. It can refer to it not as a binding decision, but as a persuasive
No,
decision.
it cannot. Council,
I want to understand the difference between
The
I want him to
the
explain
problem-
the
the
difference
problem-
between binding and persuasive.
No, the problem
Yes,
is that
yes,
he
yes.
has not read the cases we referred to him. He has not read Byarugaba, which
I've
quoted.
read Byarugaba.
And do you know that in both Byarugaba and Semuju, they talked about that Namugerwa decision?
In which way?
They said that the Constitution, the Supreme Court has to revisit that decision, and they clarified. Madrama was very categorical, who is now in the Supreme Court in the Kabaziguruka case. He was very clear that the Supreme Court cannot bind the Constitutional Court in a criminal appeal. That is not just
But
my
he's
word.
misleading. Justice
It is
Madrama
Well-
in the Kabaziguruka case in the Court of Appeal, he's one of the dissenting judges. It was a three.
Yes, he
a
wa-
3-2.
he made that clarification. You read the
And
read
no,
Madrama.
I read the case.
No,
I
you have
was
not
in the
read
Supreme
it.
Court. You are not there. I was in the Supreme
The
Court
more-
when
the more I-
Madrama was in the Constitutional Court, was not in Supreme
when
Court.
he was in the Constitutional Court when
So that
Kabaziguruka was
decision I'm
decided.
talking about, that decision of
I read the
Kabaziguruka,
case.
the decision of the judgment of Madrama is in the constitutional petition judgment of Madrama. You haven't read
Right,
it.
so you-
read
I
it
read
again.
the decision.
You-
No,
you are both
I was in
lawyers.
court
if you
in
had
the
read
Supreme
it,
Court.
so
You are both
so,
lawyers.
But
It's misleading.
Kenneth,
It's misleading the
Kenneth,
public.
the simple fact is that the last decisions, the three last decisions, two from the Constitutional Court and one from the Supreme Court this week, emphasized the category of military courts as mere disciplinary organs of soldiers, not civilians. Not towards the end, they talked about the only people who are properly before military tribunals are what? Are soldiers. It is in the Wednesday judgment of Supreme Court. It's not in the long. It's in the old decision. So
All right.
they are cherry picking court decisions. They are defying Byarugaba. They are defying Semuju, and they are defying the latest decision of the Supreme Court. If he were to be honest, he would take it page 10 of the Wednesday decision, and it will tell him what it
No,
was.
What is
I'm
there?
sure
What
they
is
have
there
it.
on page 10?
No,
Very
we can
quickly.
go there. We can go there because
Page
that
10
decision
of the ruling.
because they were agreeing that even military tribunals cannot try even service offenses. It is there.
Can't even try service
But
offenses.
it's
They
kind of
hardly try.
Rather
maybe
civil
in
offences,
that
yes.
case,
All right,
They
let
can't-
me-
let's hear from Lieutenant
No.
Wete.
The issue, when you look at the binding, Council has not cited any law that appeals, criminal appeals and civil appeals. The article.
No, I've cited
Article
Madrama.
132 No, Madrama, Madrama was part of the dissenting judges.
Yes, I'm citing him. Yes, I'm citing him.
Yeah.
In that dissent, he clarified that the the court of the Supreme Court can only be persuasive and not binding on the Constitutional Court in constitutional matters.
What it seems to say, that was the view of an individual judge, but the overall ruling was that civilians can be tried.
So
that's what it seems to say.
The Constitution.
No. The overall ruling was actually in the Kabaziguruka that civilians cannot be tried in military tribunals.
And Justice Madrama, you're quoting in the court when he was in the Court of Appeal in the Kabaziguruka case, he said the trial of civilians is.
You see, I only quoted Madrama on the question of hierarchy.
Gentlemen,
I only quoted Madrama.
You are all lawyers, and this matter is in not only in the public domain but also in the judicial system. So how can we arrive on the final decision so that we can know whether actually it is right?
So here is what I was telling you. The Wednesday decision is this. On page 10, when you go there, they quoted with approval the previous court, which said that it reasoned that the court martial or other military court did not have jurisdiction to try what? The apparent, since the offenses were not committed during military operations. That is on page 10. It is on paragraph line 10.
All right.
You get me?
I think what
so
will be interested
very
in
clear.
is to know the best way forward. How can we arrive
so
on the
the
truth?
thing is that they have to follow court orders. They have to follow the Wednesday decision, which restricts these tribunals to disciplinary organs of the military. They are not disciplinary organs of civilians. Civilians are not soldiers.
That is wrong.
Towards the end, no, we are reading. I have it here. They said that the person who was being brought out was only properly there because he was a soldier.
And not
In
because
the premises, in the premises, that is paragraph 23. It is paragraph 23, the first line, the first paragraph. In the premises, we can safely conclude that the apparent being a soldier was properly before the military tribunal. By necessary implication, and unless you are a soldier, you are not properly before what? This military tribunal.
There are quite a number of decisions.
So this is the Wednesday decision. Even if they wanted to follow the Supreme Court, not only is it the Wednesday decision, it is a Supreme Court decision.
The Supreme Court decision of Wednesday, the main issue in controversy was the link between the military courts and they
clarified. No. Akik left this one. They brought this one to handle. Let's handle with him.
Why do you want to confuse Akik? The law is very clear. I'm quoting the constitution.
You don't want me to read the Supreme Court decision?
Gentlemen were politicians.
The Supreme Court decision has said after interpreting the constitution, it has clarified that UPDF tribunals are mere disciplinary organ listening.
Let's hear from Kanodewa.
It's a kangaroo military tribunal.
How do we
It's a
proceed?
kangaroo. Not only is it a tribunal, it's kangaroo.
All right, Aaron Kiza, kindly let's listen to each other. Kanodewa.
But he has not given Council Achilles to explain. Now, if you continue shouting and nobody's listening to even us who are not conversant,
they were not shouting.
Yeah, no, you cannot. Who is listening to who now?
All right, let's hear from
anyway.
you. In light of this disagreement, you brought a lawyer. He is a human rights
lawyer. You see, these lawyers
what do we
are
do?
very
How
sure.
do we arrive
there is
the truth?
We have reached on the truth in this country for a very long time, and I have heard it of all the things. They have always said that the legal system in Uganda, the legal regime in Uganda is working. So, if there is anything that is controversial, then let the legal regime, the legal system of this country take it on and reach its conclusion. Of course, we cannot conclude it in this kind of discussion.
There is no controversy on the question of
it must be
illegal
there.
trial of civilians before military tribunals.
But
there is no controversy.
Aaron, what
so
is surprising?
you think those courts have lost all the powers to say that this must stop?
No, the courts have spoken and you are defying them. I can no, Kenneth. Let's go to the decision.
Then
of 15th December.
Let me just put a question to Aaron.
You have actually threatened to take us to the East African Court.
I have already taken you to the East African Court of Justice. I am just going to take you to criminal courts.
We shall be there.
Those generals will be detained.
Trust me, you will come back like some lawyers, I know.
Let me put a question to you, Aaron. If you say there are already decisions that have been made, in light of the Dr. Kiza Besigye trial, we have had you actually urging the Supreme Court to quickly handle the appeal by the Attorney General about the Kabaziguruka case. So it would mean that probably that's where you're looking for a solution.
No.
Is that where the solution is?
You see, the appeal is there.
You can see there is temptation on
And
touch
they have
here and
not
there.
what? And they have not handled it. I can't force them.
So can we
What
wait?
I'm asking is that the military must follow the decisions that are there. The appeal is not against Amman Byarugaba, the appeal is not against Semuju, and the appeal is not against the Supreme Court's own decision of Wednesday, all of which point in one direction. UPDF tribunals are mere disciplinary organs for soldiers, not for civilians. That came out succinctly on Wednesday. It also came out many years ago on 15th December 2022. This is what the court decided. One, that the exercise of military jurisdiction by military courts to try civilians for criminal offenses is unconstitutional. That under the Constitution, trying civilians is the role of civilian courts of judicature, which do not include military courts. Military courts are intended as disciplinary courts for UPDF to serve the public interest of maintaining discipline among members of UPDF. That was A. B. They declared UPDF Act to the extent that it may be understood as conferring jurisdiction on military courts null and void. They also ordered that criminal cases in which civilians have been charged before military courts and are pending trial or have been partly tried be transferred immediately to competent civilian courts and taken over by DPP. They also ordered that the civilians or convictions of civilians which arose during the hearing of the judgment should stand, but those ones from 15th should are null and void ab initio and any proceedings. That is the Constitutional Court on 15th December.
But
Kenneth, let me finish before Bart and
Please
if
conclude because we are
there has never
This is
been
the
any
problem. We
appeal.
have given him time.
No,
I am
I've
waiting
not-
for
no,
that
I've not
forum
finished.
for Kiza
There
to
has
finish,
never been
and we
an
revert.
appeal from this decision.
All right.
There is no stay,
Mm.
and that is 2022.
All right, very quickly, let's hear from
in the
Lieutenant
decision of Attorney General versus Tomushabe, that is civil appeal number 3 of 2005. Justice Mulenga wrote the lead judgment. All the justices of the Supreme Court concurred.
When was that?
That is a 2005 decision. Although court martials are specialized system to administer justice in accordance with military law, they are part of the courts that are deemed to be established under the Constitution to administer justice in the name of the people. It follows that the General Court Martial is both a subordinate court within the meaning of Article 129(1)(d) and lower than the High Court in the parent hierarchy. So, until a decision, he's quoting the Constitutional Court decisions. When there are Supreme Court decisions, and the law and the Constitution is very clear that he vehemently defends, and we all defend. Article 134 is clear that all decisions of the Court of Appeal, all the decisions of the Supreme Court are binding on all courts below. So that is very clear. Until he quotes a Supreme Court decision, the decision of
It came out on Wednesday, and he's not listening.
All right,
It came out on Wednesday. The Supreme Court decision came out on Wednesday.
So the decision of Wednesday is just the issue was jurisdiction. The main issue was on jurisdiction. The case that hits on the issue of the hierarchy, the nature of military courts is Attorney General versus Tomushabe. The Second Lieutenant Ambrose case is on jurisdiction, and that is the issue. These other issues are in what?
All right.
Are in passing.
All right,
I want to give some
very
some
quickly
other-
because we have feedback from the listener.
So then you look at, I don't want to look at the politics that is happening in the country, but I want to look at the law. There are issues that the UPDF deploys around the world. It deploys in Somalia, it deploys in Central African Republic, and it deploys military attaches around the world. So if a military attache reps a staff in the UK, for example, if you can't charge them under the Penal Code Act, so you bring them in under the UPDF Act, and so that is
Because
the
they are
rationale.
military personnel. They are a military personnel, not so.
Yes, but
Right, that seems to be where the issue is. But let's hear from the listeners. We have comments coming in. We have a comment from Nick who writes in and says, Kanyamunyu Matthew, who killed Kenneth Akena, was not court-martialed, yet he used a gun to kill. How come Molly Katanga, who allegedly shot her husband Henry Katanga, is not before the court martial? How come Jamil Mukulu of ADF, who is suspected terrorist, is not before the court martial? How come Tabula, who is suspected of killing the Ndiga clan head, Bosaka Keto, is not before the court martial? The Makinde court martial is a kangaroo court to selectively prosecute supposed political opponents of the NRM and President Museveni. That's a comment from Nick there. We have a comment coming in from Lydia who says, hello, Kenneth, this show today, every lawyer reads a ruling looking for what works for their case. Well, that seems to be the issue from the arguments that have been coming across. Then we have another comment. Somebody writes in and says, good evening, Kenneth. George from Bunga. This regime reminds me about my headmaster in O-level who used to make us laugh. He will tell the students, when you're a thief, you steal and steal. When you look around, there is nothing to steal. You end up stealing yourself. Now, students could burst into laughter like you can steal yourself. Now, the government, after overstaying in power now, they are afraid about the constitution which they amended in 1995. Then we have another comment. Somebody says, can the UPDF panelists tell us why they have not taken Alex Mukulu of ADF and Kweyelo of LRA Konyi to military court martial, and Akik should stop arrogance of not caring about anybody. That's a comment from Emmanuel. Alan Shaka Orlando Roysina says, greetings. First, let me make it clear that a system doesn't spare anyone. Your use of military tribunals to persecute and suppress those who disagree with you is a gross abuse of justice. This is not stability, it is oppression. Civilians deserve to be tried in civilian courts. Using the court martial to silence dissent is a hallmark of regimes built on fear, not legitimacy. Remember the regime of Bashar al-Assad in Syria, which tortured and persecuted its opponents through unjust systems. Despite this oppressive grip, it has faced immense consequences, showing that no regime survives injustice forever. Then we have another comment, Hal Kenneth and Radio 1. Their funders share some of the special competences possessed by military courts that the judicial courts don't have. Can you share? Then somebody writes in and says, I hope Council Aaron will speak with decorum, not like he has been doing lately. Intellectual debate doesn't need all that energy. Well, that's the feedback we're getting from the listeners, and I will urge you to quickly respond to some of the comments that have come across, and I'll begin with you, Deo Kiki, because majority of the comments seem to be coming, urging you to reflect on some of the ways the military court martial has been working.
Well, we have been reflecting onto this, and we have done all what we have been doing with all due diligence, and it's not the first time, but just because the current case has other political connotations, that's why we are having what we are having. There is somebody, you know, there are some people who are bullies. When you are trying to tell somebody the truth, he says you are becoming arrogant. But that is the truth. You may call it arrogance, but that is the truth. And I don't want this issue of intimidating our court members. You've heard even in those courts when some people, including our own Aaron here, calling them names. It is a way of intimidation. I know in the law,
criminals are criminals. How am I supposed to refer to criminals?
Somebody has told you to have decorum.
You can have time to respond.
Let me respond at my time you will come in. So some of those threats, you see, if you listen to every noise that comes around, then you will never do anything. So as long as you even said about it, where the likes of Aaron are waiting for certain rulings from somewhere. The other day, I was telling him, we were on another talk show. I was like, why is one of the lawyers saying it is the Chief Justice of this country that is making the court martial to continue charging civilians? I said, then you go and have your issues with that Chief Justice, not with the court martial. So there is a lot of trying to hide around certain things and not telling the public the truth. And when we come out and tell the truth, they come up with all types of intimidation. But if it is intimidation, we know how to intimidate. Actually, we can do it even better. So let us have decorum. Let's discuss issues. Let's inform Ugandans on what is happening. And these are matters that concern security of this country. We have been around for some time, and we have kept this country safe.
All right, let's hear from you, Council Aaron Kiza, as we come towards the end of this show, your closing remarks on this particular subject, and maybe the best way forward.
The best way forward is to respect court orders, which in 3 consecutive court orders, including the latest Supreme Court order, have clarified the disciplinary, the fact that the military courts are limited to disciplining soldiers. VSJ and Rotary are not soldiers. NOP members are not soldiers. Ordinary Ugandans are not soldiers. If they are not soldiers, you don't touch them. On issues of of security, illegality is not a way of maintaining security. If you want to maintain the security of this nation, follow the law, abide by rule of law, heed the constitution. There is no country which becomes stable by running roughshod over the judiciary, over civil liberties, and the military pretending to rule over civilian affairs. There is no security in that.
I'm
Thank
afraid
you.
we have to bring this discussion to an end. I must
Yes,
thank you.
not-
Yeah,
yes, not
very quickly, your
concluded.
closing remarks.
Thank you very much.
Lieutenant Bwete.
What I'll
In a
say
few
that,
seconds.
The decisions of the Supreme Court are binding, and Council has not has not presented a decision of the Supreme Court that is.
The
that
Wednesday
is
decision is
the
from
issue.
Supreme
Alright.
Court, and you are not
Jurisdiction.
accepting it
We're
as
going to
binding.
become-
Concluding.
Yes.
Conclude.
The Wednesday decision is touching the
All right.
jurisdiction.
It talks
It
about the
doesn't talk about
discipline. It
trial
talks
of
about the
With that, we
discipline.
come to the end of Spectrum. Tomorrow, another topic will be on air, and we shall continue looking at this issue. Hopefully, the Supreme Court will have a final say on
We
this
have
matter.
learned the tactics of Kiza.
And then
Next
we'll-
time we shall block him also.
All right.
We
Thank you
shall
very
all
much, dear
shout.
listeners and the guests, for actually being part of this discussion. Up next,